Mr. Attorney General, I want to offer my sincere appreciation to the administration for its daring and successful mission to eliminate Osama bin Laden. I want to commend our military, our intelligence personnel, and the administration for never forgetting 9/11 and for continuing to pursue terrorists and bring them to justice. And please bring that message back to the President. As you well know, during the last Congress, a number of us worked tirelessly to pass the 9/11 Health and Compensation Act so that we can properly honor, remember, and care for the victims of 9/11. This new law reopens the Victims' Compensation Fund, which will allow those still suffering and dying from their work at Ground Zero to finally apply for financial compensation for their losses. You and I have met about setting up the fund, and again, I want to encourage you to make rapid progress on appointing a special master, setting up the mechanisms necessary to process claims, and doing everything you can to ensure that those still suffering from the attacks will get the compensation that they deserve. And I hope you let us know if there's anything we can do to help ensure that implementation of the Act goes as smoothly as possible. Now getting back, thank you. Now getting back to the little discussion of DOMA. I don't believe that the administration had any choice in the matter at all by looking at the legal precedents. And tell me if it isn't true that Mr. Sensenbrenner was a little mistaken because he said you chose one circuit over the others. In fact, a number of circuits had established the rational relationship test. The Second Circuit hadn't established any test, which is why you had to look into the position of the Department in the Second Circuit case. What should you do? Not whether you agreed with the Second Circuit or not. It was a new question which you had to consider for the first time in a new circuit. But isn't it true that the cases in the other circuits that determined that the rational relationship test was the right test all were done pre-Lawrence and post-Bowers? In other words, they were all done in a legal context in which the Supreme Court had said that the act of consensual sodomy, the homosexual act itself, could be properly made a crime. This was specifically that was a 1986 case. It was specifically overturned by the 2003 case of Lawrence, which said you couldn't do that, and this had to give an entirely new context, and there had been no determination of the, by any court as far as I know, but certainly by any circuit, of the proper scope of review or standard of review after the Lawrence case. And if you look at the normal criteria for determining the standard of review that the Supreme Court has enjoined upon us as to what a suspect classification is, etc., does this class have a history of discrimination? Does it have the political power to stop the discrimination, etc., etc.? It meets all the tests, and you really had no choice but to go that route.
Well, I would agree with you. I mean, the legal environment, the legal landscape has fundamentally changed since some of those earlier decisions were made by those other circuits. And we confronted in the Second Circuit a jurisdiction or a circuit that had not ruled, and so therefore we had to examine the legal environment as it exists today. And on that basis, not on any political basis, but on a legal basis, a constitutional basis, the recommendation that I made to the President was that there was not a reasonable argument that could be made in favor of the constitutionality of DOMA, and the President agreed.
In a context after Lawrence, not just in a context of social change.
Exactly. In terms of what the courts have said, understanding what the court said and when they said it, what the Supreme Court said, what many lower courts have said, and then looking at the trying to decide what the appropriate standard was.
Well, I commend you for that determination. I think it was compelled by the courts. I certainly hope that we will not start trying to intimidate the Department in terms of its legal decisions through the use of the appropriations process. That would be wholly inappropriate. Let me switch topics, if I may. We have here your letter from Ron Weiss, actually, on the state secrets doctrine, and you make some very interesting points. But the key point is, the courts should have the information. You're going to exercise this power very sparingly, etc., etc. But it's still a power the executive is going to use. In the Ninth Circuit, in the initial decision of the Ninth Circuit, I thought the most important sentence was a sentence where the three-judge panel said the executive cannot be its own judge. And all the criteria which you set forward in this letter are fine criteria, but they all say, in effect, trust the Department, trust the executive branch, no recognition of separation of powers. That, and my contention is that you say in here that the Department recognizes that courts have an essential and independent role to play in reviewing the executive's assertion. it should be in approving the executive's assertion. There should be secret proceedings and so forth, if necessary, but the key is that the court should have to okay or not an assertion of the fact that a motion to dismiss on the grounds of executive privilege should have to be okayed by the court, not simply noted by the court, regardless of how restrained and proper the executive is. That seems to be fundamental to our system of checks and balances and completely missing from the department's position.
Well, what I've tried to do is really reform the process by which the invocation of that privilege is made. There are a whole series of levels of review that have to be agreed to, including by the highest levels in the Department of Justice, then I ultimately must agree that the invocation of the privilege is appropriate. Since this new process is put in place, we have only invoked the privilege on 2 occasions, and we only will do it in those instances where it's necessary to protect national security and not to hide anything that might have been appropriately done by the executive.
All of which... The gentleman's time has expired.
May I have unanimous consent for an additional minute?
The gentleman is recognized without objection for an additional 30 seconds.
All of which may be true, and all of which may be exercised properly by you and maybe by your successor or not, but the decision is still reserved to the department, not the court. And that's the fundamental problem, which I think is inconsistent with our general system of government.
Well, as I said, I think we have in place a new process that handles the concerns that you have, and we make sure that these invocations of the privilege are rare and are appropriate.